New York views marriage as an economic partnership. In a divorce, the courts will follow the rule of equitable distribution. That means the court will do what is equitable or fair in dividing a property. Usually the court will divide property 50-50. However, if the court believes that a different division is fair, they will have the authority to divide property as they see fit. When divorcing, the first step is to determine which property is subject to equitable distribution and which is separate. The general rule is that all property acquired by either spouse during the marriage is subject to equitable distribution. This includes businesses, real estate, retirement accounts, and pensions. There are several major exceptions to what property is subject to equitable distribution. This includes the following: property acquired prior to the marriage, property acquired after being legally separated, property acquired after the commencement of a divorce action, property acquired by either through inheritance, property acquired through a negligence action such as an auto accident or slip and fall, disability payments. This includes only the disability payment and not the pension portion, property purchased by one party through the sale or trade of separate property, property received by one party as a gift from a third party, and property agreed by the parties in a prenuptial or postnuptial agreement to be separate property. Property that would be considered separate can become marital property during the marriage if it was put in both parties' name or otherwise commingled. For example, if the owner of a bank account adds the spouse's name to the account, the money in that account is subject to equitable distribution. Separate property can also become at least partially marital property if its value was increased due to the efforts of the non-titled spouse. The increased value would be subject to equitable distribution. For example, if one party purchased a house in his or her own name prior to marriage, then after the marriage began, the non-titled spouse contributed his or her own money to renovate the house, the increased value of the house due to the renovation is subject to equitable distribution. Once the parties agree, or absent such an agreement, the court determines which property is subject to equitable distribution. The court will determine a fair apportionment of the property between the parties. Among the things the court will take into consideration are the following: income of each party at the time of the marriage, income of each party at the commencement of the divorce action, property of each party at the time of the marriage, property of each party at the commencement of the divorce action, duration of the marriage, age of each party, health of each party, need of the custodial parent to occupy or own the marital residence, need of the custodial party to use or own the household effects, loss of inheritance rights upon dissolution of the marriage as of the date of dissolution, loss of pension rights upon dissolution as of the date of the dissolution, any award of maintenance, formerly known as alimony. Equitable claims to interest in or direct or indirect contribution to the acquisition of the marital property by the party not having title, including joint effects, expenditures, contributions as a spouse, parent, wage earner, or homemaker, and to the career or career potential of the other party, liquid or non-liquid character of all marital property, probable future financial circumstances of each party, impossibility or difficulty of evaluating any asset or interest in the business, corporation, or profession, the desirability of retaining the asset or interest in the business, corporation, or professional free from any claim or interference by the other party, the tax consequences to each party, the wasteful dissipation of assets by either spouse, any transfer or encumbrance made in contemplation of a marital action without fair consideration, health insurance of the parties, such other factors that the court shall expressly find to be just and proper. My name is Jeffrey Peltz. For over the past 25+ years, I have helped thousands of clients with family law matters. I invite you to look through our website for more information on division of property in New York and our law firm. When you're ready for more information, call us toll-free at 855-625-0800 to schedule a free consultation either by telephone, video, or in our office.